My name is Robert Volterra. I am a public international law practitioner. I also teach public international law at UCL and King's College, University of London. In this video, I will give an overview of the attempt by a group of people to scam an enormous amount of money from and to harm the sovereign interests of Malaysia. They are trying to do this by way of an illegal scam that has become known around the world as the case of the sham Sulu arbitration. On 2 November 2017, 8 individuals who say that they are descended from the last Sultan of Sulu brought a claim against Malaysia. They claimed that they were entitled to be paid 5,300 Malaysian ringgit annually by virtue of an agreement dated 1878 entered into by their long ago ancestor, the last Sultan of Sulu. They claimed that Malaysia had stopped paying them that money as of 2013. Eventually, they tried to start a Spanish commercial arbitration against Malaysia to obtain financial compensation. These 8 individuals claim that Malaysia leases a part of the Malaysian state of Sabah in northeast Borneo from them by virtue of an 1878 agreement. They appear to base their claim on being successors in interest of the last Sultan of Sulu. And through the sham Sulu arbitration that they started under the Spanish commercial arbitration law and in Spain, the so-called heirs of the last Sultan of Sulu are trying to swindle $15 billion from Malaysia as compensation for Malaysia's having stopped sending them 5,300 Malaysian ringgit annually in 2013. This astonishing claim by the so-called heirs of the last Sultan of Sulu is contradicted by a clear and uncontroverted trail of public historical documents stretching back some 150 years. This includes the document on the public record by which the last Sultan of Sulu ceded the territory that is now a part, but only a part, of the Malaysian state called Sabah. To help you understand how this scam unfolded, I will start by recounting the relevant history of the Malaysian state of Sabah, formerly called North Borneo. In 1878, 2 men, one called Baron de Overbeck and one called Mr. Alfred Dent, on the one hand, and the Sultan of Sulu, on the other hand, entered into an agreement in relation to certain parts of Sabah, which was at the time called North Borneo. This 1878 agreement, on its own terms, is an agreement by the Sultan to hand over territory to the British colonial company being incorporated by Baron de Overbeck and Alfred Dent. The payment for this cession of territory was 5,000 ringgit per annum. Under the terms of the 1878 agreement, the territory could not be transferred to any other nation or to any non-British company without Great Britain's approval, and any controversy between the parties about the agreement was to be referred to the local British Consul General. This type of acquisition of colonial territory by a state through the initial intermediary of persons or companies that are nationals of the colonial state was not uncommon during the European colonial period. It was a device used by European colonial powers as a recognized way under public international law for a state to acquire sovereign territory abroad. Great Britain used this colonial tool around the world, including in relation to North Borneo, as it was then. Indeed, as I teach my students, this manner of acquisition of sovereign territory, indirectly, in stages and via colonial companies, by European colonial powers, was not unusual. A similar process happened in relation to the East India Company and the British Raj. In relation to the North Borneo territories in question here, a treaty entered into during the first half of the 20th century by de Overbeck and Dent's company, called the British North Borneo Company, a representative of Great Britain, and the Sultan of Sulu, confirmed that the 1878 agreement proceeded to the cession of North Borneo, as it was then called. The tripartite agreement also increased the annual payment to 5,300 ringgit. In addition to this legal title derived from the legal grant of the territory by the Sultan of Sulu, Sabah eventually became a part of Malaysia by virtue of the exercise of self-determination by the peoples living there. When Britain began its decolonization of Southeast Asia, a British government commission determined that the peoples of Sabah wanted to join in statehood with Malaysia. A UN fact-finding mission shortly thereafter also found that the peoples of Sabah were in favor of joining Malaysia. Subsequently, the treaty forming the Malaysian Federation, which included North Borneo, was signed. We now turn to the infamous sham Sulu arbitration, concocted by the so-called heirs of the last Sultan of Sulu, about whom I've been talking. Since its formation in 1963, Malaysia had paid cession monies to the heirs of the last Sultan of Sulu of 5,300 Malaysian ringgit per year. Although Malaysia was not legally obliged to do so, it chose to pay the same annual amount to the heirs as was set out in the 1878 agreement. However, in 2013, a terrorist group called the Royal Army of Sulu attempted an armed invasion of Sabah. After that incident, Malaysia stopped paying the cessions money to the so-called heirs because of concerns that it was being used to fund the terrorist activities of this Royal Army of Sulu. It is open to speculation as to whether the same concerns apply to the attempt to extract monies from Malaysia by way of the sham Sulu arbitration. So 4 years later, after 2013, so in 2017, the so-called heirs of the last Sultan of Sulu presented a claim to Malaysia for the unpaid arrears of the cessions money. Remember, when I come to the part where, a few years later, the sham arbitration supposedly awarded them 15 billion US dollars, their claim against Malaysia was for a few thousand ringgit. When Malaysia declined to respond to the so-called heirs' claim for the cession money's arrears, the so-called heirs threatened Malaysia with an investment arbitration claim under an ASEAN treaty. The so-called heirs soon abandoned that attempt at arbitration and turned to the British Foreign and Commonwealth Office in London for help. They did so on the grounds that the 1878 agreement of the Sultan of Sulu referenced the British Consul General in Borneo. The UK Foreign Office turned them away after concluding that the chain of succession and the obligations, if any, under the 1878 agreement were not as straightforward as these so-called heirs asserted. So they then hired a Spanish law firm to start an arbitration against Malaysia in Spain, of all places, and under Spanish commercial arbitration law. It is not clear why this group of Philippine nationals went to Spain to start a commercial arbitration agreement under an 1878 agreement between a British colonial enterprise and the Sultan of Sulu. Nor is it clear why they thought that the 1878 agreement, which refers to any controversy being referred to the British consul, could provide a legal basis to bring an arbitration against Malaysia anywhere, let alone in Spain and under Spanish law. Under the Spanish Arbitration Act, where two parties have agreed to arbitrate a dispute but they do not agree on who will be the arbitrator, either party can apply to the Spanish courts to appoint an arbitrator. And this is what the so-called heirs did. They asked the Spanish courts to appoint an arbitrator. But the heirs did not involve Malaysia in that process. So Malaysia did not participate in the Spanish court proceeding because the so-called heirs had not properly served Malaysia with a writ of summons to the Spanish courts. Despite this, curiously, the Spanish court initially, but only initially, appointed a Spanish lawyer called Mr. Gonzalo Stampa to be an arbitrator. Malaysia did not participate in this so-called arbitration. Instead, Malaysia challenged the appointment of Mr. Stampa and went to the same Spanish court that had initially appointed him to ask that that appointment be undone. Malaysia presented the Spanish court with the evidence of how the so-called heirs had not properly commenced the arbitration proceedings and violated Malaysia's sovereignty as it exists under international law and under Spanish law. When the Spanish court learned the truth, which it had not been told by the so-called heirs, it reversed its earlier decision to appoint Mr. Stampa as an arbitrator, and it annulled all the decisions that had been taken by Mr. Stampa since his initial improper appointment. This annulment by the Spanish court included annulling a partial award of jurisdiction and applicable law that had been purportedly issued by Mr. Stampa, and in which he had perversely decided that the 1878 agreement included an arbitration clause, and also decided that he had jurisdiction to decide the claim. The judgment of the Spanish court reversing its earlier decision and overthrowing the arbitration proceeding was clear. It was also binding on the claimants and on the arbitrator. The Spanish court reversed its earlier decision and declared that Mr. Stampa was not appointed as an arbitrator under the Spanish Arbitration Act. And this means that under Spanish law, and remember, this arbitration, this supposed arbitration, exists only under Spanish law. The Spanish court said that this meant that under Spanish law, Mr. Stampa was never an arbitrator, and there was never, therefore, any arbitration against Malaysia under the Spanish Arbitration Act. The so-called heirs appealed this decision all the way up to the Spanish Constitutional Court, but they failed. They failed and Malaysia won. Relevantly, the so-called heirs initially complied with the Spanish judgment, and so they took steps initially to appoint a different arbitrator. But then they stopped when, surprisingly, Mr. Stampa decided to continue with the original arbitration proceeding from which he had been removed clearly by the Spanish courts. We can currently only speculate why, but Mr. Stampa chose not to comply with a Spanish court order removing him. Instead of complying with Spanish law and the Spanish courts, Mr. Stampa decided to continue the original proceedings as if he had been duly appointed and continued to be duly appointed under the Spanish Arbitration Act. Incredibly, and presumably because he knew that he was flouting a Spanish court order by continuing in this way, Mr. Stampa then purported to move the sham arbitration proceedings to France. Now, just think about that. First, the sham arbitration was commenced and legally existed under Spanish legislation via the Spanish Arbitration Act. But second, the Spanish courts ordered the annulment, the inexistence of Mr. Stampa's supposed appointment as arbitrator under Spanish law. Third, Spain and the Spanish courts determined that Malaysia's public international law rights as a sovereign had been violated by being improperly served by the claimants. And then fourth, after all that having been decided by the Spanish courts, after having been removed as an arbitrator under Spanish law by the Spanish courts, Mr. Stampa purported to move the process to France, deliberately to try to escape the legal effects of the Spanish court order removing him. So thereafter, in flagrant violation of the Spanish court judgment and thus the Spanish law under which the sham arbitration had supposedly been taking place, the procedure took place in Paris. Mr. Stampa never informed the French courts that his appointment under Spanish law and all of his decisions had been retroactively annulled by the Spanish courts, nor did he ever tell the French courts that the so-called heirs had initially returned to Spain after the decision of the Spanish courts unseating him to restart their claim to appoint a different arbitrator under Spanish law. This sham Sulu arbitration was not based on any agreement or consent by Malaysia, which has never waived its sovereign immunity. Nor was the sham arbitration based on any domestic arbitration law. It certainly was not an arbitration with an arbitrator appointed under the Spanish Arbitration Act. It is in flagrant violation of a judgment to the contrary by the Spanish courts. The so-called heirs of the last Sultan of Sulu and Mr. Stampa had no legal basis to proceed with the sham arbitration, and certainly not by running away from the Spanish courts to France to continue with it. And, as the Spanish courts have made clear, Mr. Stampa had no jurisdiction to reach any authoritative decision in relation to the claims of the so-called heirs against Malaysia. Despite this, just over a year ago, on 28 February 2022, Mr. Stampa published his views about the claim in a document that he labeled a final award. Mr. Stampa, in that so-called final award, incredibly felt that he had the unilateral authority to decide that the 1878 agreement was now somehow terminated. He decided that it was terminated as of 1 January 2013. He also astonishingly decided that Malaysia should pay the alleged heirs a breathtaking $14.92 billion as compensation. From start to finish, this infamous process was a sham. It was not a valid arbitration because Malaysia never agreed to arbitration. Arbitration is a voluntary form of dispute settlement. It requires all the concerned parties to agree to it. It is essential for an arbitration that there be an agreement to arbitrate. Without that consent from each party, there can be no arbitration. The so-called heirs of the last Sultan of Sulu say that the 1878 agreement between Overbeck and Dent and the Sultan of Sulu provides Malaysia's consent to arbitrate. But this is simply false. There is no reference to arbitration in the 1878 agreement, none whatsoever. The parties to that agreement in 1878 merely agreed to refer any controversies to the British Consul General. So there's no reference to arbitration. There's no reference to Spain. There's no reference to the Spanish Arbitration Act, nor to any Spanish lawyer acting as a judge to decide any dispute. More importantly, as from the day in 2021 when the Spanish courts annulled the appointment of Mr. Stampa was no longer an arbitrator. In fact, he was never an arbitrator because of the retroactive effect of the Spanish judgment. The Spanish courts had decided that the flaw in the claimant's service of the writ of summons to Malaysia for the initial appointment process vitiated and exterminated the entire appointment proceedings, and therefore there had never been any arbitration. Therefore, Mr. Stampa had no legitimate basis by which he could render any award on the claim of the so-called heirs of the Sultan of Sulu. The claim presented by the so-called heirs relates to Malaysia's sovereignty over Sabah. This is a matter of public international law. Yet the so-called heirs and Mr. Stampa decided that Malaysia had to pay $15 billion based on a general commercial law set of principles arising from the 2016 UNIDROIT Principles of International Commercial Contracts. Those are generic commercial law principles that have been discussed and agreed at the United Nations. They're not applicable in any particular country per se. It is not the substantive law to determine issues relating to a state's sovereignty over its territory. Not only that, the 2016 UNIDROIT legal principles did not exist until more than 135 years after the 1878 agreement. So there's no way that the parties to that agreement thought that these legal principles were going to be the applicable law. In fact, those UNIDROIT principles did not exist until 3 years after any dispute about the 5,300 Malaysia ringgit session monies ever arose. Malaysia is taking action to stop this sham arbitration having any effect. What this is an attempted swindle on a massive scale internationally. A dispute possibly about the payment of a few tens of thousands of dollars at most has been leveraged into a $15 billion attempt to get money from a country. It is an attempted arbitration scam. It would be a violation of the concept of the rule of law were the claimants allowed to succeed in capturing this illegitimate windfall. Malaysia will not tolerate such an attack directed against its sovereign interests. In relation to the Sulu arbitration sham, Malaysia has persistently objected to it from the start. The scam should have been stopped once the Spanish court ruled that Mr. Stampa was not validly appointed as an arbitrator under the Spanish Arbitration Act. It was a violation of the Spanish court judgment for Mr. Stampa and the so-called heirs to take their procedure across the border to France in an attempt to avoid the Spanish court judgment. But Malaysia is vigorously defending its rights. The government of Malaysia has repeatedly stated publicly that it will resist any attempt on the part of the claimants to take any money from it arising from this sham Sulu arbitration, including attempts to get money arising from any enforcement proceedings of the so-called final award before the courts of any country. Malaysia has made it clear that it will continue to do everything in its power to ensure that all the perpetrators of this sham arbitration face the applicable criminal and regulatory consequences of their acts. Malaysia will not sit idly by and permit the theft of $15 billion from the people of Malaysia.